Okay, we're going to go ahead and get it started. Good evening, everybody. My name is Tom Bevan. I'm with the law firm of Bevan and Associates. In a minute, I'm going to introduce our lead counsel on this project, Michael Watts, but just wanted to say a few things first. And I know it's been about a little over 14 months, I think, since that train derailment that really changed everybody in this room's lives. And a lot has gone on these last 14 months, but we understand that the concerns that you have, the doubts, the issues that are going on in your life, and how this derailment has impacted your lives. And attorneys from our group, as well as other attorneys out there, have been working really hard trying to bring some resolution to this process. And I think we're still a long ways away from there. I know you have a lot of questions. I've got a lot of questions as well. I've talked to some of you that we've been representing for the past over a year now, and I understand your concerns. We're weighing the fact that this has had a major impact on your lives, on your property, on your community, with the fact that you also want some kind of resolution and want that resolution to be as quick as possible. So we understand all those factors. We've been doing this for a long time, and we've had cases that have taken 10, 15 years to resolve, and we've had other cases that we can resolve in a few years. But I'm going to turn it over to Michael right now. He's going to give you some more information regarding this proposed settlement. We have a number of questions that were submitted to us online, and so Michael's going to try to address those questions in an orderly way, so we can give you guys as much information as we're able to give you today, and then we'll keep in touch going forward as to how this process is moving on. So, Michael.
Go ahead. Thank you. No, don't clap. Guys, thank you for coming. I don't normally wear a suit and tie, as you know. I'm here in a suit and tie because I'm actually in a case down at the courthouse in Chicago. But last Monday, the 9th, when this got announced, the very first call that I made was to Tom's firm and to our local folks, and I said, rent the cinema, rent the school over in Pennsylvania. We need to get down there in a hurry and answer everybody's questions. So hopefully you got an email on the same day that you read the article saying we're going to come with details. I'm very pleased that some of the lawyers with whom I've worked that have really worked hard on this are here to help us answer these questions. And if I can make this damn thing work, then we'll be good to go. Tom Kelly, good Lord. There we go. Okay, so I'm going to start off, and then after I get done talking about what led us to this, I'm going to call up a couple of my colleagues, Seth Katz and Adam Gomez, who kind of led the effort in some ways to get us to where we are, to answer specific questions about the settlement. As you know, I've been here 4 or 5 times over the last year trying to keep you updated. I think the last time I was here was on the night of the 20th of December, and trying to tell you what was going on and the like. Let me give you a little backdrop about where we've led, because it's very important in terms of your consideration of this settlement that you just don't read a 4-sentence blurb in a newspaper article or somebody's supposition that, you divide this by a number of people and everybody's going to get $4,000. That's just absurd. And I'll explain why that is and the like. But this is our judge, the Honorable Benita Pearson. She's a United States Federal District Court judge in Youngstown. She has been, to put it politely, incredible and outstanding in terms of trying to get this case done as quickly as possible. And she's the reason, together with some hard work, that we're here. Her work started about a year ago when, right after all the lawyers got together, there was a leadership order. And in that leadership order, she appointed my friend Seth Katz, with whom I'd worked on previous cases, Elizabeth Graham with the law firm of Grant and Eisenhower, that's Adam's partner, and Jane Conroy, who I'd worked with on opioids, as the interim class counsel. And class lawyers are a little bit different than individual lawyers, but here we work together, which was good, and it's the way it should be. Those 3 class lawyers, together with my friend Mike Morgan of Morgan & Morgan, you've heard of them, became the lead counsel. and worked together with the rest of us to put this together. There was an executive committee upon which I sat, together with some other good lawyers and a whole bunch of people on what's called a plaintiff's steering committee. The court got involved and set up the chairs of subcommittees and liaison counsel and the like. And so the thing got organized very quickly. I think it was last April. She told us to all get in a room. We did. I think I even told you that we had a meeting that Seth hosted in Cleveland, if I'm not mistaken, where we got everybody organized in a hurry, and the judge entered this leadership order, and it's been solid work ever since. All right. A lawsuit has what's called a burden of proof. We are the people who brought the lawsuit. We have the burden of proof. So you can't just show up and say, there was a big train derailment, pay me. There's parts of a lawsuit called liability, who's at fault, damages, how much are they at fault for, and then that leads to recovery. We have the burden of proof not only that they screwed up and caused a train derailment, you didn't need lawyers for that, but also to show what was the extent of the damages so that we could achieve a recovery on your behalf. Now, liability. Really, there's two different aspects of that. There's 100, but if you group them all together, first was the company at fault. Now, as I like to joke, you don't have to be Clarence Darrow to prove that a company that jumps the tracks screwed up. But we had to show how and why and all the reasons, and so there were a litany of depositions that were taken by good lawyers across the United States. But on damages, we have to show the presence of contaminants, not just that it was released, and we know what was released, but what was deposited upon your properties, and therefore the potential causation. And so the presence of contaminants at a certain level is our burden of proof. So we did a lot of testing. And then you have to take that testing and you go to the field of what's called epidemiology, which is science that has looked at past exposures of similar levels of contaminants being present and see whether or not the science says that leads to an increased risk of this cancer or that cancer and the like. And so, fault, presence of contaminants, science showing the presence of those contaminants is statistically likely to lead to an increase in cancer risk. And so that's what we've been dealing with over the last year. To say that there were a lot of lawyers that worked very hard, taking a bunch of depositions would be an understatement. Your judge, who very much wanted this done quickly, put on a schedule that was as rapid as anything I've ever seen. Literally multiple depositions, seemed like every day. When Seth called me and asked me to take the deposition of the engineer and the conductor, I said, sure, that's great. He didn't tell me it was like the day before Christmas. But that's my point, is the judge said, I want this done by the end of January. And so there were tens and tens and tens of depositions done after hundreds of thousands of pages of documents were read. There were third-party depositions. There were non-parties deposed. And all this had to be done by February the 1st. And by and large, it was done, thanks to the leadership of these guys at the time that the judge wanted it done. And only after that was finished and all the testing was finished could the parties have the sufficient information to get together at the settlement table to negotiate what's being presented to you as an option. Now, I've told you in previous meetings, we know what got released. There were 6 different chemicals that were released. We know what they were. We know which cars they were in. We know how much got released. And we know that, in effect, because of the combustibility of those chemicals, it in effect created dioxin, which is not a good thing. But that's not enough to win a lawsuit in an environmental tort case. You have to show not only that it got released, but through air modeling and soil sampling, that it actually ended up in the particular properties where the plaintiffs were. You have to show the level of that together with the epidemiology to be able to prove up some causation from the standpoint of the injuries that were alleged. So personal injury damages are different than property damage, the cost to get this junk out of your houses and the loss of real estate value and the like, very different. So in personal injury damages, we have to show the presence of the contaminants, epidemiology, in order to have an inference of causation. That is a very different kettle of fish than saying my property damage or my property value has gone down because of all the negative press and because of the pollution that we know is here. So think in terms of 2 different elements, personal injury versus property damage. Now, we spent a lot of time, and a lot of folks have spent a lot of time trying to demonstrate the presence of contaminants through testing. Again, different kinds of testing, air sampling, soil sampling, and then testing that got into your bodies or not through blood and urine testing. All of those are necessary for different parts of a personal injury case, and we'll talk about why in a second. We weren't the only ones doing testing. The United States Environmental Protection Agency did testing. Ohio's EPA did testing. Norfolk Southern did a bunch of this testing to show nothing was wrong. We did a bunch of testing showing something was wrong. Universities around here did a bunch of testing. And so there's a lot of data points that we had about where the testing was done and what the contaminant levels that were shown in that testing demonstrated. And so I guess my point here is, over the last 14 months, we're not guessing. The parties did enough testing, they know what ended up where, regardless of what somebody in the newspaper may have said. Okay? The testing is the proof that you have to show up with in a court of law. Now, why is that important? Here's a diagram that Seth sent me. It's super important. There is a demonstrably different level of contamination if you're within 0 to 10 miles of the area of the derailment than if you're within 10 to 20 miles of the area of derailment. It's just what the testing showed. Okay? It is objective evidence, regardless of what people think. The fact is that all of the testing from all of the party shows greater contamination within 0 to 10 miles than within 10 to 20. And frankly, as we go further out, and you see all those red lines that I put into Seth's graph here, the contaminants, I'm going to call it virtually non-existent. It's not that they don't exist. They don't exist at a level that we're going to be able to show any causation to injury. And so it's virtually non-existent from the standpoint of 20 miles out and more, from the standpoint of causation, and that makes the chances of success for people more than 20 miles out much lower. And so that's the importance of the testing. Now, you've heard me talk about a case called CSX versus Hirsch, or Hirsch versus CSX. Remember, this was a previous train derailment where there was a lawsuit filed saying, oh my God, there was a derailment, there was a release of all this toxic stuff. We think it increased our risk of cancer. We want you to pay for everybody in the community to do what's called medical monitoring. It's a medical monitoring cause of action, which sounds great, and I'm sorry you really can't see this, but the bottom line is in the CSX case, the Sixth Circuit Court of Appeals, remember that's that Court of Appeals above Judge Pearson, she has to follow their law, said in effect, it's not enough that you had a bunch of stuff that spewed out, and in effect they suggest, while it's not a requirement in this circuit, if you had blood testing, if you had urine testing, show it actually made its way into your body, then you might have something. But without that, you don't, which is why in several different meetings early on, I said, if you can get your urine tested, get your blood tested, do it, because you're going to need some objective evidence other than there was a big derailment, other than there was a big contamination. And that's why I was asking you all to get that done. If you didn't get that done and you are unable to show it was inside your body, Judge Hirsch, in effect, dismissed the medical monitoring cause of action. It's not because she's a bad person or doesn't like the case. She was a great judge, but she is duty-bound to follow the precedent of the Sixth Circuit Court of Appeals in Hirsch versus CSX. Okay? Now, she did say that the need to do medical monitoring may be an element of your damages, and we'll talk about that in a little bit, but it's not an independent cause of action giving you a right to money from CSX. All right, so again, personal injury presence of contaminants, epidemiology showing causation. Now, what is epidemiology? You take the presence of a known contamination and you compare it, in effect, to other known studies that looked at the consequence of that level of contamination. I'm way oversimplifying it, but there's got to be a past increase in sickness when that level of contamination exists. So it's not enough that you had an increase in sickness from some other community because a particular contaminant got released, it's got to be at the level that you're finding in your testing. And so all of that is necessary, and then you do a statistical significance test that increase in sickness based on the same level of contamination allows you to infer causation. And so we had a bunch of epidemiologists looking at all of these different chemicals and saying, what does the science show is the relative risk of cancer causation if you have contamination at the levels that we know from our testing that we got. And so the bottom line is that's what you need for causation. Your job is to look at the evidence and decide what you want to do. My job is to not sugarcoat the evidence, okay? We found what we found. The liability evidence is really strong. It's one of the strongest liability cases you've ever seen. The damages evidence with respect to personal injury for most of you is not strong. And so that makes the best recovery achievable for property damage, a loss of value of your real estate, the cost to clean it up, versus being able to recover a bunch of money for a potential of cancer that may or may not come, because we lack the science to show the causation between the level of contamination that we have and cancer in a lot of different instances. So, I'm going to bring Seth up here in a second, but the bottom line is the parties got all this evidence together, all of the depositions, all of the testing, all of the epidemiology. They started comparing notes in front of a guy named Lane Phillips. Now, Lane Phillips is a former United States district judge. He's now probably the most prominent mass tort mediator. He's a third party that both sides respect that we go in front of to have settlement discussions. Seth and some of the other folks in leadership met with him on several of occasions, had a whole bunch of calls, and we're negotiating back and forth, and Seth's going to give you a lot of details about this. But the bottom line is this gentleman made a mediator's proposal of $600 million, and at that point, it was up to the parties to decide whether to recommend that to their clients. So the leadership of the plaintiffs had to decide that this is something we think we should recommend to the plaintiffs writ large, and the lawyers representing Norfolk Southern had to recommend it to the board of directors of Norfolk Southern, who had to approve it for the settlement to become enforceable. So all this was super hush-hush until April the 9th. What happened on April the 9th? Early in the morning, Norfolk Southern put out what's called a Form 8K. And that is a document that publicly traded corporations are required to file with the Securities and Exchange Commission if there's a material event that affects the bottom line of the company. When you have a big settlement like this, you have to disclose it at some point. And so, in effect, in that 8K, they did. And they said, we have a proposed East Palestine derailment class action settlement, and the press saw it. And that's when you saw it same day, okay? In every one of these settlements, they have to be first or it's a violation of SEC rules. We're not allowed to talk about it until they disclose it. They put out a press release on their website, and of course you've heard this phrase, making it right. That's what they're saying they're doing with every dollar they spend here to make you feel better about them. But the bottom line is they say this $600 million settlement underscores commitment to making it right. It was picked up in the national news immediately in the Washington Post, in the New York Times, pretty much all over the United States, local, both in Ohio and in Pittsburgh. And so you started immediately getting folks like the folks outside that were interviewing folks, what do you think about this? And the bottom line is that, as with any settlement, people say, well, is that enough? I can tell you this is the largest railroad settlement in the history of the country by a factor of 4, I think. It's unprecedented. But is it enough? That's a decision that you all are going to have to make. Before we get into the details of what the settlement says, I do want to tell you that both of your United States senators have been on this, consulted about this. In January, the United States House packed into a bipartisan tax bill some tax relief, what's called the Tax Relief for American Families and Workers Act of 2024. It's got a provision in it. I just overshot it. It's got a provision in it that's called Section 404, in effect. And Sherrod Brown is trying to pass it on the Senate side, and in effect it would make your recovery tax-free. And Sherrod Brown just sent a letter to the Internal Revenue Service trying to get this done. What he really needs to do is get the Senate to pass it, go with the House, Conference Committee, and the like. So what does it say? Section 404 has a specific provision for East Palestine, and it says in effect that if you recover any money from Norfolk Southern or any governmental entity or Norfolk Southern's insurance company, it's categorized in a particular kind of disaster relief that alleviates your normal tax burden with respect to that. So that's what's been happening from my perspective. I've seen some articles, which is one of the reasons that I said immediately we've got to start having these meetings. Some backlash, lawyers defending. We're not here to defend or to argue with you. We're here to give you information. We are the hired help. You are the clients. You decide. This is a class action settlement that's kind of a hybrid. If you want to opt out of the class action, you can. On the personal injury side, you can choose to participate or not with the consequences that come from that. What the lawyers have been asking for the last week was come get the details. Now, I did two things on April the 9th. When I heard that this was going to get announced, I called my folks and said, we need to immediately have a town hall. And they said, won't you be in trial in Chicago? I said, I'll go after court. We cannot wait. I'll be in trial the next month. Okay? You're entitled to the information. It's one of the reasons we're videoing it for the people that aren't here. The other clients can get the information, and they can start making their choices. So we've had these 4 town halls. Perhaps this is the most significant one. We're here to give you the details. The second thing is my friend Seth Katz led a call, and of course we knew about it a couple days before, and we had to keep that secret, and that's appropriate. But as soon as it became public, I called him and I said, hey, can you guys be here? We've got the theater booked for next Monday. We've got the high school over in Pennsylvania booked. Can you be here as the folks that were in the negotiation room to give the details? And so Seth and his folks and Adam prepared a PowerPoint that they're going to take you through. And so what we'll do is we'll let Seth and or Adam talk about the PowerPoint that they prepared, and then we'll open it up for questions. I think we got 984 calls the first day, so there's a bunch of pre-printed questions, and we'll go from there. So this is Seth Katz, one of our lead counsel. Go with that one, right? Okay.
Thanks, Michael. I guess I'm going to take this off so you can see the PowerPoint also. Evening, everyone. My name is Seth Katz. I am one of the court-appointed co-lead and interim class counsel. I've been involved in this litigation since almost immediately after the derailment. My firm and Adam's firm, Grant and Eisenhofer, we went to court within a day or two of the dust settling at the site to prevent Norfolk Southern from moving evidence so we can collect evidence, and we've been leading that charge since then, and lucky enough to get appointed by the court for this. So let me give you some of the high-level terms. It's a $600 million settlement that Norfolk Southern will pay. It's all new money, so to the extent Norfolk Southern has paid money to the community through the Family Assistance Center or otherwise, they're not getting a credit for that. Money will not revert to Norfolk Southern if it's unallocated. It will go back into the community through supplemental distributions. Those are two very important terms for people to understand. The next piece of this, and there's been a lot of misreporting, that you just take the $600 million and divide by the number of people that live in the 20-mile radius, and that's what everyone's going to get. That could not be further from the truth. Awards will be based on claim forms that have to be submitted with different criteria that are still being finalized, but proximity to the derailment site will be the most, or one of the most important factors in all this, meaning that the people that live, work, and were there closer to the derailment site will be awarded more money than someone who is at the 20th mile. That's just the way the process is going to work. It is designed to be streamlined, be easy for people to participate and fill out their claim forms. The level of proof is well below what you would need to prove in a lawsuit. Michael went through what you need, liability, damages, causation. We don't have to do that here, and you will not have to do that as part of the claim form. Additionally, there are other lawsuits that this does not resolve, namely the suit brought by the government for cleanup costs and continued cleanup of the communities. So there are what we'll call two property residential classes, 10 miles and in, 10 to 20 miles. We're going to use the criteria that are being developed, and like I said, proximity to the derailment site will be a driving factor in it, number of days outside your home, things like that. These are the damages being paid as a result of the loss of use of enjoyment of your home because you were out of it, loss of use of enjoyment of your property, nuisance, loss in value. And Michael mentioned that the court had to dismiss the claim for medical monitoring, but the payments for medical monitoring are going to be included in this component of the settlement. And just because you get an award that falls in this bucket, people can use the money for whatever they want. But the claims that are being asserted against Norfolk Southern are being released, which means they're going to pay this money, and that's it. It's part of a class action. What does that mean? It means there was a group of class representatives who participated in the litigation. They sat through depositions. They had their lives turned upside down. They collected documents so that not everybody had to. Then, because it's a class action settlement, it has to be approved by the court. And the next step is preliminary approval, and we're going to hopefully be making that motion to tell the court that this settlement is fair, reasonable, and adequate. Later this week, the court will rule on that, and at that point, we hope she approves the settlement preliminarily, and we can start sending out notice, providing claims forms, getting a claims center open in East Palestine for people who need help. But because it's a class action, it's not mandatory. You can opt out. You can decide this settlement's not for me, and I don't want to participate in it, keep all my litigation rights, and opt yourself out. That is certainly within your right. But if you don't opt out, you will be included. So you need to submit a claim form if you want to participate. In order to receive an award, you have to submit a claim form. If you don't opt out and don't submit a claim form, you will not get an award, but your rights to bring litigation in the future will be extinguished. So it's important to look for the notice. We're going to do direct mail. We're going to do publication, so you'll see it in the news, you'll see it on a website, you'll see it in social media, and that claim form is how you can get considered for an award. After preliminary approval, there's the claim process. Once all the claims are processed, we have to ask the court for final approval of the settlement. And when we do that, we're hoping that that will be this fall, and if all things go smoothly, payments can begin in December. The third, so here are some of the criteria we're going to use. Now, these are examples. This process still has to go through the preliminary approval process by the court to determine how we're actually going to do this.
I hate to interrupt you. Lori Slowinski, your green Jeep is about to get towed. Go ahead.
One thing, I said Norfolk Southern's not going to get a credit for money that they've already paid out of the claim center, but if an individual class member received money from the claim center or another source, that money will be considered in your award. So you're not going to be able to get the same money twice, but it won't go back to Norfolk Southern. It'll go back into the community through supplemental distributions. And I think everyone would consider that fair, that if you received $1 already from the community center from Norfolk Southern, not to receive that same dollar twice, but then to have it distributed to the community. Here are some other issues. Because it's a class action, it's got to be approved by the federal judge, Benita Pearson. She's got to follow different standards. then we know, she's got to look at it's fair. Is it reasonable? Is it adequate? Was it negotiated at arm's length? And I can promise you it was. It was negotiated hard by both sides. Like Michael said, we engaged one of the country's most renowned mediators for large cases. We had multiple sessions with Judge Phillips. We had multiple calls between sessions, after sessions, and ultimately he made a mediator's proposal that both sides accepted and advised the court. Because it was a class action, we had the class representatives who went through the litigation process so that you guys all didn't have to. They're members of the community just like you, they have to be. In order to represent the community, they have to be a part of the community, and they were. And without them, and I don't know if any of them are here in the audience, but a great thank you to them for participating in the litigation. Court has to approve the notice plan, which will be submitted, and then, like I said, final approval. We're targeting for the fall and payments by the end of the year. The third class are business owners. Okay, so if you own a business in the 20-mile area and you suffered a net loss in 2023, and you can prove an actual net loss, you'll be compensated for it. Again, if you received money from other sources, whether it's Norfolk Southern or otherwise, we'll take that has to be taken into consideration. And if all the claims in the business bucket don't exhaust it, that money does not go back to Norfolk Southern. It goes to the community. It'll go to the class, what we've called the residential class in that first ring, the people most impacted. So the claims process is going to be designed to make sure the people most impacted, most likely the people that are the closest into the derailment site, will be the most compensated. And as we get further out and further out and further out, the compensation the criteria will show those compensation amounts will be lower. So business, you're going to need to have actual proof, and the ideal proof is your 2022 tax return versus your 2023 tax return. Like Michael said, if it were in a lawsuit, you'd have to prove causation. Here in a settlement, you don't. You just have to show the loss. These are the class areas. The interior red circle is the 10-mile radius, the yellow circle, the broader radius of 20 miles. So the final piece of this that is not a class action, it is a voluntary component. It's only available to members of the community that are within the first 10 miles for personal injury claims, okay? It's not a class action, so in order to participate, you have to voluntarily participate. If you do nothing, you won't get an award, but you're not giving up your right to sue later. If you do participate, you will be eligible to receive additional compensation above the class settlement, but you will be releasing your ability to sue Norfolk Southern later for other personal injuries that you may suffer in the future. So you would get a payment now, but you'd be releasing your litigation rights. The advantages are you don't have to go through the lawsuit. Like Michael said, you don't have to prove causation. You don't have to hire the experts. You don't have to go through and get your life investigated as part of discovery. So, there are definitely a lot of advantages to participating in it. And again, voluntary, you do not need to participate, but we do think that it is an added benefit to this community to get money to the people that need it now. Examples of the criteria that will be considered for the personal injury part. Again, location, distance from the derailment site, whether you had symptoms or not, whether or not you received treatment and what it was, whether you had a formal diagnosis and what it was. People can elect to participate in the personal injury piece of the settlement, even if they didn't suffer any kind of personal injury now. The personal injury component presumes if you were within the 10 miles, you had some exposure, and you can apply for additional personal injury compensation now, regardless of whether you got treatment, regardless of whether you had any symptoms. but you'll be releasing the ability to do so later. This is the 10-mile area broken down in 1-mile bands so people can have a visual and kind of get an idea of where you might be on this graph in relation to the derailment site. And then this is really the first 3 miles, 2 miles, and then the extra mile of the area most impacted by the testing we did. So just a visual of where the core zone is. So those are the basic terms. I know Michael said we'd give some information about the mediation process, and unfortunately it's confidential. There's a mediator's privilege that we cannot talk about certain things beyond that. We had a number of sessions that they were hard fought, and that as a result of the mediator's proposal, we spoke with the class representatives, Norfolk Southern spoke with the people it had to speak with, and both parties within the deadline given to us by the mediator determined that this was in the best interest of, in Norfolk Southern's case, their client, and in our case, the communities that the court appointed us to represent.
And I'm going to ask Seth to stay up here and answer questions, but I do want to say this. You'll note that we didn't say anything about what happened in the mediation. That's an important part of it. But the bottom line is these guys worked for weeks and weeks and weeks and weeks and worked really hard and got it done. And as somebody that's in a lot of these big-time cases, I just want to vouch for the people that ran the class in this case. I'm a guy that, no, I've got it. I'm a guy that fights with class action lawyers a lot, and this man put together a team that created no space between those of us representing individuals and those doing the class. It was completely cohesive for the last 14 months, and the leadership gets a lot of credit for that. We're swimming in the same direction down the stream. So in terms of the questions that we already got, let me just see if we can go about this and get Seth's thoughts on it. The first question or topic area, there were 986 calls we got on the day of this announcement. We tried to put them into categories. First one is settlement amount and eligibility. Many inquire about the expected compensation for residents within various radius distances from the derailment site. Questions also arise regarding entitlement criteria for families, individuals, and businesses, as well as the differences in payouts between groups living within different proximity ranges. I think Seth's graphic with the concentric circles kind of explains that, but if you have any other thought, fire away.
It's impossible at this point to know what any one class member, be it an individual, a family, a business, will get as a result of the claims process. The word that, or the advice we have is, submit your claim. The claims process will be as objective as we can. It will be streamlined. It will focus on making sure that the members of the community most impacted get the greater awards. It will be fair. It will be overseen by a court-appointed claims administrator. Norfolk Southern is not going to be participating in the actual claims process. We will have an on-site claims office, assistance center, support center in East Palestine. It will be manned or womaned or staffed by the claims administrator. Plaintiffs' lawyers will have a role there. Norfolk Southern will not. So if you go into there and you are talking with people, they are people that are either on the plaintiffs' lawyers team or the court-appointed claims administrator.
Just one other thought about that. If it was just a personal injury settlement and you had somebody like me representing a lot of you, I'm not allowed to rob Peter to pay Paul. I'm not allowed to make a judgment in your favor as opposed to her favor. Here, because we've got the protections of a class settlement, you have the additional oversight of an independent third-party claims administrator, not Seth and I arguing about whose client's more valuable, but more importantly, you have the notice, you have the right to object, you have the right to go in front of the judge and say this isn't fair or not. And so there's all sorts of safety protections there to make sure that this is done in an honest and forthright and fair manner. Second question, or sets of question, health issues and future coverage. I think we've answered this one as well. Concerns about health problems resulting from the incident, such as respiratory issues and long-term health monitoring, are prevalent. Individuals seek clarity on whether future medical claims will be covered and how compensation will address health-related expenses.
For the personal injury component, that will take into account the risk of future illness. But the money that you receive as part of that claim will come with a release of future litigation against Norfolk Southern or any of the other parties that are being released in order to get that compensation. So you can get that compensation now without going through a lawsuit, without having to meet the burdens associated with bringing individual personal injury litigation. And as far as the cost of medical monitoring, the class component awards for the first 20 miles will have a piece of that you can use that money for getting future testing. If your doctors say, hey, every year go get a blood test or this test or that test. You can use the money that you receive as part of that award for that, because that is the claim or piece of the claim, damages for the claim that's part of this settlement.
Now, I know the answer to my next question, but I'm the host and he's the guest, so I get to ask it even though I know the answer. Can we have our cake and eat it too, where we can participate in the property damage class to get our house cleaned up, get paid for the reduction of property value, but preserve our right to sue later for personal injury, cancer, and the like by not participating in that side?
Yes. People can certainly participate in the class settlement, but not participate in the voluntary personal injury component if they'd like. The personal injury component is there to enhance awards so that people can get their money now, do what they want with it, spend it, invest it, and those kinds of items. And as part of the settlement, we are attendant to the settlement. It's not really part of the settlement. We're going to do our best to deal with the tax issue. Certainly that is not part of the settlement, but we're working with some of the senators. We've got in the audience Michelle Krantz, who was the court-appointed liaison, who's the president of the Ohio Bar, and she's already spoken with both J.D. Vance's folks and Sherrod Brown's folks about the tax issue. So it's something that we have no control over, but we are pressing it as best we can on behalf of the members of the community. We're also going to try to do our best to make available to people streamlined process for if people want to invest in the future, annuities, those kinds of things, getting resources. Again, that's not part of the settlement, but it's information that we'll be providing so that people who might decide, I don't have a personal injury now, I'm going to participate, take my award, invest it in an annuity, because these latent diseases have a 15 to 20 year latency period, so I can let that money grow should I get sick in the future, if I get sick in the future, and I may never get sick in the future, and I can utilize that money with the growth interest.
A couple of things that I would just tell you. There are no two senators in the United States Senate farther apart politically than Sherrod Brown on the left and J.D. Vance on the right. But you, the people of Ohio, deserve some credit, because both of these people, way on the opposite end of the spectrum, acted like adults in a Senate full of children for your best interest. There's been very little space between them. And I think our people who have advocated and talked with those folks are just impressed by whether you're a Republican or a Democrat, both of them are working for your interest. The second thing that I would say is this. Before you have to decide whether to put yourself at risk by taking money now before you know whether you're going to get cancer 20 years from now, you're going to have this incredible vault of information that's going to be publicly made available from the standpoint of the motion for preliminary approval. We have to justify things about why 0 to 10 is different than 10 to 20. There'll be a lot of evidence put forth in the public record with respect to that before final approval and the like. And so my point is that there are all sorts of procedural safeguards designed to give you the information you need to make that choice. It's a long way of saying you can participate in the property damage class action and choose not to participate in the personal injury side so you preserve your rights. Okay, third, legal and procedural matters. Queries regarding paperwork submission, participation in the settlement, and the involvement of legal firms are common. Some inquire about opt-out options from the class action lawsuit and potential continuation of mass tort lawsuits. I think we've answered that, but if you got something else, fire away.
Yeah, look, it's a class action. You certainly always have the right to opt out and pursue your own litigation. The outcome of that would be unknown at this point, where it would go, how long it would take. I mean, Michael said at the beginning, there are the lawyers here in the room. We've all been involved in cases that are still going, and they're 14, 15 years old. You know, so that's a risk of litigation. The settlement eliminates all those risks. The risk of zero, the risk of losing, the risk of having to overcome the legal hurdles under Ohio and Sixth Circuit law. The need to prove your case beyond your civil litigation burden. The need to not deal with alternative causes. So there are a lot of advantages, in my opinion, to participating in both the class and the personal injury side of this settlement. But again, that's not a one-size-opinion-fits-all. It's got to be looked at individually.
You know, part of Seth and Beth and Adam's, you know, job here is kind of risk mitigation, trying to get you as much money as we can, as early as we can, before bad things have happened. And I'll just tell you, as your lawyer, I practice law all over the United States. You have an exceptionally good United States District Judge. I've never seen it done better. But she has to follow the law of a United States Court of Appeals. It's the Sixth Circuit. There are 13 circuits all across the United States. The Sixth Circuit ain't my favorite for this kind of lawsuit, large part because of the Hirsch versus CSX case, okay? So don't pretend that just because we have this outstanding judge that's been pushing the case and doing all these great things, that you're out of the ditch if she rules for you, because anything she does will go up to the Sixth Circuit Court of Appeals, and Norfolk Southern damn sure will appeal adverse rulings, okay?
And don't think that the lawyers handling this case don't understand that everybody in this room, given the choice of getting a check or having their life restored to how it was on February 2nd or the morning of February 3rd of 2023, wouldn't take having their life restored. Don't think that escapes us. Don't think we don't understand that. However, the legal system doesn't allow for that. So, you know, please keep that in mind as well.
Yeah, the one other thing I would tell you is that I said I vouch for this effort. You know, Seth and his team have led calls that we've all been on once a week for, 70 weeks now. And it's been consistent, it's been persistent, it's been hardworking. You wouldn't believe the amount of legal work that was going on over Christmas. Okay, nobody sat down for a minute, and these are some of the best lawyers in America. I've practiced with a lot of them. We don't have the B team here. You have the A+ team working together in a very cohesive fashion for your benefit, and that's what's led to this option that you have to participate in this proposed settlement. Now, speaking of the settlement, the next set of questions, distribution of settlement funds. Questions revolve around how the $600 million settlement will be dispersed among affected individuals and whether compensation amounts will vary based on factors such as proximity to the incident site or property ownership. And I think you already know the answer to that.
Yes.
Okay. Next category, documentation and proof. Individuals seek guidance on the type of documentation required to demonstrate loss, particularly for businesses affected by the incident. Let's stop there. How do you prove up a business case? He already said it.
Yeah, you know, I think for the business, the best proof would be comparing years' tax returns. You know, obviously there are other documents that'll be acceptable, but your typical business documents that show a net loss are the things you're going to need to collect. As far as the class component, you know, whether it's a deed to the property, whether it's, you know, if you're a renter, a lease, the typical things, a utility bill, the typical things that will prove what we would all consider residency. If you were an employee who didn't live in the 20-mile radius, but you worked, you know, one of the Main Street businesses, your W-2 that shows where your employer was. So, you know, we're trying to make this streamlined, easy, efficient, and kind of the common sense levels of proof that you would show to prove whichever component of the class you're in.
Okay. I have to be in Pittsburgh in less than an hour, so let's keep going. There are also inquiries about accessing medical records and submitting additional damages or discrepancies. Let me take this just for a second. If you were one of the huge number of people that could not breathe, that had the watering eyes, that had the burning and everything like that, and you went to a medical professional, get your proof now, okay? The amount of money somebody that contemporaneously went to get medical treatment versus somebody who never did will get is astounding. But in litigation, they will not take your word for it. I've done these exposure cases where people that were in Boston that day, according to their Facebook, say that they were in Corpus Christi, Texas, when we had a refinery explosion. I've had wildfire cases out in Northern California where people say they had a 500-pound emerald that melted, despite the fact that nobody ever had a picture of it, and it wasn't insured, and nobody had ever seen it before. And so they're going to require documentation of medical treatment. So if you got that treatment, start getting the documentation now. You'll get paid more if you have the documentation than if you just say, I went to the doctor, and the doctor doesn't have any record of you being there. Okay. Property damage and value. Concerns extend to property damage, diminished values, and potential compensation for homeowners with larger properties. Some inquire about payments for damages to property and whether Norfolk Southern has admitted guilt. Some inquire about compensation for multiple properties and personal belongings affected by the incident, including whether landlords can claim compensation for rental properties. Let me take the middle question. Have they admitted guilt? In every one of these settlements, they say this is no admission of liability. But where I come from, when somebody parts with $600 million, that tells you all you need to know. Okay? Now, with respect to proving up property damage, tell them about the expert on the lawsuit.
So we one of the countless experts that we retained was a preeminent expert in property valuation and diminution in property values. And, you know, look, like Michael said, in a lawsuit, you've got to prove causation. And, you know, this settlement does not take into account the need to prove that the loss in value was a result of the derailment as opposed to increase in interest rates or just decrease in the economy. So proving those damages in a lawsuit is going to be a much different component than proving or claiming them as part of the claims process. And again, we think that's another advantage of participating in the class action settlement, because that is a component. Again, when you get an award, you can spend the money however you want, but the lawsuit sought damages for, among other things, loss in value of your property, so that class 1 or class 2 component, that is a payment there.
Let me tell you why that's big. In any lawsuit, the defendants come up with 1,000 other reasons why what you're complaining of happened. One that I can think of right off the top is the explosion of interest rates and the effect on real estate valuations, because people don't have the money to buy, and so demand has gone down and therefore prices have gone down. The beauty of this part of the settlement is you show that reduction. You don't have that causation fight.
Yeah.
Okay. Opt-out and exclusion. Questions arise regarding the possibility of opting out of the class action lawsuit and continuing with individual lawsuits. I think he's answered that. Individuals also seek clarification on whether they need to have an existing claim to be included in the settlement. Answer that second one.
An existing claim, if you live, work, own property within the 20-mile radius, you are a member of the class and are entitled to submit a claim. So I think that is kind of a defining group. If you're in the 10-mile, you have the potential to submit a claim for the personal injury.
Okay. Community meetings and support. I think he's told you it's coming. Some comments reference community meetings and support gatherings indicating a desire for collective action and information sharing among affected individuals. What I can tell you is this. In the same time that I'm in trial in Chicago and I'm here after court, when I called Seth and said, we're going to be here on the 15th, can you come? He said, not only will I come, I'll have people there to answer any questions that we have. Seth and one of us joked, I think, that they're moving to East Palestine. There's going to be an informational overload available to you because part of their job as class counsel is to, in effect, give you the information you need to decide whether to participate. Any other thoughts?
No, you covered it.
Scope and radius of the settlement. Questions emerge regarding the geographical scope of the settlement, including the effective radius and its implication for compensation eligibility. You're going to have to wait to see the briefing with respect to the motion for preliminary approval and the motion for final approval. What I can tell you is that with respect to some of you, the evidence is very strong. The farther you get out, the evidence becomes less strong. And generally after 20 miles, it's just really tough. And so it's really hard to get somebody to pay money when the evidence that we've collected makes it highly unlikely that we'd be successful in court.
Yeah, so, like we said, proximity to the derailment site, and as you get farther out in those 1 mile increments, will drive a lot of the claim awards, the point system, those kinds of things. So, put your claim in, show your proof of where you were, where you live, where you work, what your losses were, things like that. And, the one thing that I do want to reiterate, and I know a lot of people, we saw it in the newspaper, on a news report, oh, it's only going to be $4,000 or $6,000 because it's 600 million divided by how many people. That is not true. That is not accurate information. Not everybody will receive the same amount of money. It's not just take the money, divide it by the number of people. You cannot do that. That is not the way this works.
All right, documentation and testing. Individuals seek clarification on the documentation needed to support their claims, such as medical records. I've addressed that, as well as whether soil and water testing will be provided as part of the settlement. I think it's already been used to build the models that led to the settlement.
Yeah.
But I can vouch, there is a ton of testing that's been done, and it doesn't lie.
Yeah, the testing and the discovery we did is what led to where we are and how we determine the radius. So that is done, and then the settlement itself does not provide for any action by Norfolk Southern other than paying money. But people can use that money however they want, like I said, and if you want to have additional testing done of your soil or something like that, you can use the money for that purpose. You can use it for any purpose.
Now let me softly disagree with what he just said about doesn't require any action. He's right. But this does not settle what's known as the CERCLA lawsuits. Explain the significance of the fact that the CERCLA lawsuits are still going.
So the government has a claim against Norfolk Southern that is not impacted by this settlement. That settlement will go forward. It's brought by the Attorney General, and it will proceed, and CERCLA is the environmental cleanup action to clean up the air, soil, and water. So that is unimpacted and will proceed, and Norfolk Southern will have to deal with that as it's doing. That's actually pending in front of a different judge than Judge Pearson, and it's moving forward.
Now, if you're outside the 20 miles, you're not happy, and I understand that. You have a right to bring a lawsuit. You just do. You also have the right to prove a lawsuit, pay for experts, do your own testing, do all this stuff. And I would just caution you that as somebody that watched 100 of the best lawyers in America test, I don't believe that somebody outside 20 miles is going to be able to find a test that all of a sudden makes a lawsuit that all these guys missed viable. So I'll just throw that out. Now, one last thing I want to do, and then we're going to get on the road to go talk to your compatriots across the state line. I do want to make a special thanks. Seth Katz did not have to be here. Adam, all of them didn't have to come. He jumped on it. I cannot tell you enough, as somebody that's done this for 35 years, what an outstanding job these lawyers did, and it was an honor to get to work with them. There's lawyers and staff from, I think it's close to 100 law firms that have worked on this for you. Not looking for a blue ribbon, but I want you to know there's a lot of people that worked hard. Tom Bevan, our local counsel, his folks, Anjali and Josh, they've been here for you from the start, and so I thank them. Our staff, who is right down the street on Main Street, Stacy Reinhart, Beth Kozar. I thought Bernie was going to be the MVP of this case until Beth got involved, and she's just been here outstanding. Jackie Grimm, it goes on and on. Adam, Nate, all of them are here for you. You go to our office, you'll get all the information you need. They've done a really good job. And of course, you know how to get a hold of us, eastpalestinejustice.com. You can visit the office at 319 North Main Street here in Columbiana, or you can call us at 330-584-9084. And so that's your information. Thank you for coming.
And just one other comment. The reason that we came from out of state, across the state, was to make sure that you guys were getting accurate information, because we've seen a lot of news reports that did not have accurate information, so it was important to the leadership that the court appointed and me personally to make sure you had the information. The preliminary approval papers will have more information. They'll be publicly filed. They'll address what happens outside of 20 miles and our view of the merit of those cases. So you can also look at those. Thanks, everybody.
Hey, guys, in the materials you were given, there's a blue card where you could write down questions. Obviously, we're not getting to them all. Write them down, take them to the office. I will answer them. Okay, all of those categories of questions that we had Seth answer were the results of people asking questions. And I'll do one better. I'll forward them to Seth and other people that are doing this to make sure that you're getting the kind of information. And frankly, they want your questions because that allows them to fill out the informational stuff, the notice, and the kind of stuff that we need to get to the entire class so that everybody can make an informed decision. So again, thanks for coming, guys.